So, good evening guys, good evening sir. I am LORENZANA and I'm going to report about contracts, Article 1305 to Article 1310. So, let's start and let's discuss this Article 1305. A contract is a meeting of minds between two persons whereby one binds himself with respect to another or to give something or to render some services. So obviously, Article 1305 provides for a legal definition and contract and study meeting of minds. Ibig sabihin, ang pagtatagpo ng dalawang isipan between two persons or pwede rin two parties. So kailan ba nagkakaroon ng meeting of minds and kailan masabi na nagtagpo na ang isipan ng dalawang parties? So it takes place when an offer by one party is accepted by another party. So doon nagkasundo and nagkaroon ng agreement. To emphasize, let's have a question. Is it necessary that contract must be in writing? The answer is no. Why? Look at the definition of contract. It is the meeting of minds. So meaning it is not necessary na nakasulat siya, except na lang doon sa mga contract na mayroong exemption. Katulad ng mga contract na nire-require ng batas na kailangan maging valid ito. So, kailangan naka-in writing talaga siya. So, now let's distinguish contract from obligation. Ayan. So, this contract is one of the source of obligations. Yung obligation must be broad. It is the legal tie or relation that exists after the contract has been entered into. So, no obligation, there will be no contract, and obligation exists without contract. So, no obligation, no contract, malamang kapag sa isang kontrata, if there is no kumbaga pag ikaw ay nag-enter sa isang contract, malamang may obligation yan. 2 or more obligation ang pwedeng nakapaloob sa isang kontrata. And depende sa napagkasunduan. But in an obligation, pwedeng mag-exist obligation without a contract. Example, may mga obligation tayo which is nanggaling sa batas mismo. Ito yung mga tulad ng law, quasi-delics, quasi-contracts, and etc. So now let's distinguish the contract from agreement. All contracts are agreements and not all agreements are contracts. So malinaw naman ito sa inyo. So not all agreements are contracts. Example dito is nagkaroon kayo ng friends mo ng agreement na manood ng sine. So nagkaroon ng agreement but not a contract. Next, let's discuss the stages in the life of contract. So, first, there is preparation or conception. Ito pa lang yung preparatory step, which will lead us to the perfection of the contract. Kumbaga, bargaining point pa lang. Like yung may nag-offer, pero wala pang, hindi pa nagkakasundo o wala pang napapagkasunduan. And then, after ng bargaining point, doon sila nagkasundo. And dito lumalabas ang perfection, the second stage of life ng contract. Dito na yung merong nagkakaroon ng meeting of minds regarding the subject matter and the cause of the contract. So, third stage is yung consummation. Ito na yung point kung saan yung parties have to perform their respective obligations, and so the contract is to put an end. So, that's all. And next, now let's discuss the classification of contracts. First, a contract is classified according to the perfection or formation. Sabi, pwede siyang consensual. Ito yung kapag perfected by mere consent. Example nga is yung sales. Binenta mo yung sasakyan mo and pumayag, so by consent. So, second naman is real contracts. Ito naman is perfected by delivery. Yung example nito is yung contract ng deposit, pledge, or yung comodatum. Kailangan ma-deliver yung object para ma-perfect yung contract. So, next, according to degree of importance. So, there is principal. Can stand alone such as sale, barter, deposit, and loan. Accessory. Its existence and validity is dependent upon another contract such as pledge, mortgage, and guarantee. So, example nito nga is yung mortgage. Kailangan, meron muna siyang principal obligation which is loan. So, tapos, i-attach doon si mortgage. So, si mortgage ay isang accessory contract. Next, according to name. So, first, nominate. With a special name such as pledge, barter, and lease. So, ito yung mga meron ng particular name na na-identify na ng batas. Example, yung mga contract ng partnership, contract ng sales, contract ng agency. So, second is nominate without any name. Hindi pa ito nabigyan or wala pang designation or special name. Hindi pa siya na-identify ng batas. So, next, according to cost or equivalent bail of prestation, there is onerous. When we say onerous, then dapat meron siyang equivalent valuable consideration. Dapat meron siyang interchange. Gratuitous kapag free. Yung isang parties ay walang matatanggap na any equivalent prestations kasi nga ito ay for free. So, next, according to nature of obligation. First, unilateral, where only one of parties is obliged to give to do something such as comodatum, gratuitous deposits, and gratuitous motum. Ang ibig sabihin ng unilateral contract is that there is only one of the parties ang may obligation. Example is yung comodatum nga. Like, naghihiram ka ng bisikleta, so you have obligation na i-return yung bike na yon afterwards. And then, second is bilateral, where both parties are obliged give or to do something such as sale, barter, and lease. So, both parties required to render prestations. Example is yung sa sale. Yung isang party is yung seller has an obligation to deliver, tapos si buyer has an obligation to pay the seller. So, both of them has an obligation. So, according to subject matter. First, contract is involving things such as sale, barter. Contract involving rights or credit such as stock or assignment of credit. Contract involving service such as agency, lease of services, and contract of carriage. So next, let's have discuss the Article 1306. So, this Article 1306, the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So this provision talks about the freedom to stipulate, the right to enter into contracts. Actually, it is one of the liberties guaranteed by the Constitution. So, general rule, yung parties are actually free to stipulate into anything. So, sabi nga, can establish such stipulations, clauses, terms, and conditions as they may deem convenient. So, free tayo mag-stipulate na kahit anong gusto nating maging kasunduan. However, there is limitations. Provided na yung contract ay legal, sabi nga ng 1306, provided they are not contrary to law, morals, good customs, public order, or public policy. So, pag ito yung mga limitations as stipulations. Pag contrary sa kanila, so hindi siya pwede. Example is yung contract na vote buying. Diba, binibenta yung boto. So, that is contrary to law and of course to public policy. So, yan yung mga limitations sa principles, freedom, or autonomy of contracts. So, next, Article 1307. Article 1307, innominate contract shall be regulated by the stipulations of the parties, by the provisions of titles 1 and 2 of this book, by the rules governing the most analogous nominate contracts, and by the customs of place. So, as I discussed kanina, meron tayong contracts na may name or specific name or designation in law, like yung sale, pledge, loan, etc. But then there is two contracts na innominate. Kumbaga, hindi pa napapangalanan at wala pang specific designation sa batas. Or ito yung mga innominate contract. So, si Article 1307 provides for the answer kung ano ba ang mag-govern sa kanila. Sabi, ang mag-govern doon sa mga innominate contract ay yung first ay yung stipulation of the parties mismo. Next is yung mag-govern din sa kanila is yung provision of titles 1 and 2 of this book. Actually, it refers to the law on obligation and contracts. So, these innominate contracts, ang mag-govern sa kanila is si obligation and contracts. So, third is who is the most analogous or ito yung mga closest contracts. So, yung mga closest contracts will also govern the contract. And the last is yung custom of the place. Usually, yung mga unique contracts which are specific to that place. So, there is classes of innominate contracts. So, first, do or test, I give you and you give. Is an agreement in which A will give one thing to B so that B will give another to A. Will give thing another to A. Second, do or facials, I give and you do, is a contract under which A will give something to B in order that B may do something for A. So, the third facial or test, I do and you give, is an agreement in which A binds himself to do something for B so that B will give something to A. Fourth, facial or facials, I do and you do, is a convention whereby A is to do something for B so that B will render some other service to A. So, next is Article 1308. Article 1308, the contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. So, we are now with another characteristic of contract, which commonly referred as the principle of mutuality of contract. It's actually simply put, a study is both parties are bind, meaning that the principle is based on the equality of the parties, and contract should not be left or should not just depends upon the sole will ng isang parties lang. So, yung both parties are on the same footing. Yung dalawa or yung kung ilan silang nasa kontrata. Hindi pwedeng isa lang ang magde-decide. After all nga, that your agreement, kumbaga, lahat ng parties, our parties to that contract. So, hindi pwedeng pag-ayaw ng isa, kumbaga according to his wills and biases. Remember, Contract is an agreement which will give rise to an obligation. So, a contract can be renewed, revived, extended, modified, renounced, terminated, or kahit ano pang gusto mong gawin dyan. Kailangan may mutual consent ng parties, ng both parties. So, there is mutuality of contract or mutual of consent. So, lahat kailangan may say, hindi lang isa. So, its validity or compliance cannot be left to the will of one of them. For example, sa loan contract, hindi pwedeng si creditor, si creditor has sole discretion or unilateral right to adjust interest anytime as he want. Hindi pwedeng siya lang yung magde-decide. Dapat pumayag yung lahat ng parties na nandoon sa contract. Kung pumayag yung parties na yun, dun pwede siya mag-adjust ng interest anytime as he want. So, I have example here. Pogi agree to sell his car to Ganda and Ganda agree to pay 1 million. And stipulation stating that Pogi alone will determine or adjust the price of the car and Ganda has no right to negate Pogi's decision violates mutuality of contracts. So, Pogi sell his car and Ganda pay 1 million. So, bad bargaining in itself does not necessarily violate mutuality of contracts. So, next is Article 1309 and Article 1310. So, Article 1309, the determination of the performance may be left to a third person whose decision shall not be binding until it has been made known to both contracting parties. And Article 10, that determination shall not be obligatory if it is evidently inequitable. In such case, the courts shall decide what is equitable under the circumstances. So, for example, dito is Gaia sold her parcel of land to Laura. It was agreed that Maya, a real estate appraisers, would be the one to determine the reasonable price of the land, and Maya then fixed the price after considering the factors affecting the value of the land and informing both contracting party that the decision is just and suitable. If the decision made by Maya is manifestly inequitable, the court may be called upon to decide what is equitable. So that's all my report, and thank you.